On September 29, 2017, a New Hampshire jury put a price on what Michael Gill had spent 3 years saying about three men. $274,500,000. $92.5 million of it to a Manchester real estate developer, $97 million to the president of an auto group, $85 million to the chairman of a bank. By a wide margin, the largest defamation award in the state's history. Gill did not attend the trial. He had no lawyer, and when the court entered final judgment the next year, the signed order fixed the figure with interest and costs. A separate court had already found him liable to a fourth man, his own former lawyer, in a case that would produce its own $5 million judgment. How does a man end up owing more than $250 million for what he put on a billboard? The answer doesn't begin in a courtroom or in a mortgage office. It begins at a racetrack. I'm Dorian Russell. Let's put it on the record. Quick reminder, because it's the whole point of this channel, every claim in this video gets graded on screen by how hard the proof is. Court record, documentary, or just reported. I'll tell you which is which as we go. When something is only reported, press, advocacy, or Gill's own websites, you'll see the red tag on screen, and I'll say so. One housekeeping note, because the name causes confusion. This is Michael J. Gill, Michael James Gill, of Plaistow, New Hampshire, the mortgage man and the racehorse owner. He is not the late Michael D. Gill, the former federal official who died in Washington in 2024. Different man, no relation. Everything in this series is about the New Hampshire Gill. And a heads up you'll want later, an attorney named Alexander Walker turns up twice in this story. Once as Gill's own lawyer, and once as a man Gill drove into court. They're the same person. Hold on to that. Before the billboards, Michael Gill was, by the numbers, one of the most successful racehorse owners in the country. In 2009, his stable led North America with 370 wins and roughly $6.7 million in earnings. He'd won the sport's top owner award, the Eclipse, back in 2005. By his own accounting, he spent some $51 million on racing over a decade. Keep that height in mind. It's the height everything after this falls from. The first public collision came in 1995. According to press accounts, one of Gill's horses tested positive for a banned bronchodilator, clenbuterol. A barn search followed, then an 80-day suspension and a $1,000 fine. And Gill refused to pay it. That refusal cost him far more than the fine. He was barred from racing until he paid, which he didn't do until 1999. A penalty answered with refusal. The refusal answered with a longer exile. Remember that shape. It comes back. In March 2003, a magazine ran a piece questioning Gill's extraordinary win rate. Gill sued for defamation in federal court. He never won a verdict on any of it, but the case left behind a published federal appeals opinion, and that opinion preserves, in a court record, the strangest episode of his racing career. As the opinion tells it, a private industry watchdog had been investigating Gill's horses since January of that year on confidential tips about race day medication. On February 3rd, one of his horses was injured and euthanized at the track. When the track's veterinarian went to test the horse's amputated front leg, it was gone. It was later recovered from one of Gill's own veterinarians who admitted taking it without permission. Now, fairness requires the rest of the record travel in the same breath, and it cuts both ways. On one side, the remaining tissue tested negative for banned substances, and Florida's regulator closed its investigation of Gill's trainer without bringing a single charge. On the other, in the opinion's own footnote, the court noted the investigative file did contain evidence that Gill's barn was involved in giving a horse an illegal milkshake, that his grooms acted as lookouts and tried to misdirect the investigator, and that his trainer and vets had prior discipline. None of that was ever proven against Gill. Its discovery record background, recited by an appeals court, and the regulator referred the veterinarians, not Gill. Both halves are true at once. That's the record. The court's actual ruling, by the way, was narrow and procedural. It kept the informant's identity sealed and expressly took no view of the merits. In 2005, Gill's own attorney dismissed the case. Gill returned to prominence running a high-volume claiming stable at Penn National in Pennsylvania. And in the last week of January 2010, 2 of his horses suffered catastrophic breakdowns in 3 racing nights. The second one breaking down past the wire and bringing down another horse. Roughly 25 jockeys then refused to ride against Gill's horses, citing safety. That boycott is now anchored in a federal trial record. An email in evidence names the threat, though the safety claims themselves were never adjudicated. Now here's where I have to slow down because there's a number in this story that gets thrown around a lot. How many of Gill's horses died? And the honest answer is that no 2 sources agree, and I'm not going to pretend they do. The Associated Press reported that 10 of his horses broke down over 13 months. PETA, 2 days later, said those 10 were euthanized. Industry charts, as reported at the time, showed 14 incidents. Breakdowns, pull-ups, lameness, easings, in the final 3 months alone. And Gill's own accounting was 7 breakdowns in 820 starts. Watch what just happened. Broke down, euthanized, incidents, breakdowns. 4 sources, 4 different verbs, 4 different numbers. No primary count was ever published. And here's the part I can now say on the record. None can be. We asked Pennsylvania, under its right to know law, for the necropsies and the race day reports. The state's answer in writing, necropsy reports of horses that die on a licensed track are exempt from disclosure by regulation. And the steward's reports for the 2 breakdown dates and for the day Gill was ejected, purged, destroyed under the retention schedule. So these 4 numbers are the ceiling. Nobody, not his critics and not Gill, can ever check them against the primary records. I'm going to leave each number attached to the exact word its source used, and the disagreement between them is the most honest thing I can show you. 2 pieces of context ship with that, because each cuts a different way. 1. Penn National had its own safety crisis in 2008. A horseman's group counted 14 fatal breakdowns in 22 days, and the track was shut down and resurfaced. And the one record Pennsylvania did give us says the resurfacing is not the end of that story. In June 2009, the Horsemen's Association put a photographic report in front of the State Racing Commission contending the rebuilt track had failed from its very first day of training. Horses cutting through the cushion, down to the limestone base, and that the fix, coarse sand, left the track so hard that the concussion injuries were spiking. 4 track farriers swore in notarized statements that the foot injuries were the worst of their careers. A veterinarian wrote the track was, quote, the hardest it has ever been. The track's operator, by the association's own account, said the surface was sound and blamed overworked horses and training methods. Nobody ever ruled on it. That report never mentions Gill, and it stopped 6 months before his cluster. And a track horseman told the trade press in early 2010 that by then the track was safe. I'm not adopting either side, but you should know the dispute exists in the state's own file. 2. Gill's own defense, spoken to the AP the day he was ejected, quote, "The autopsies of my horses, they were clean. They were sound." And that answers a doping question with toxicology. But the criticism at its strongest was never about drugs. It was about whether running unsound horses at high volume put them on the track to break down. A clean autopsy doesn't answer that. No regulator ever ruled on it either way. And with the necropsies sealed, his claim about them is now exactly as uncheckable as everyone else's numbers. On February 2nd, 2010, Gill was ejected. Not by the track, that's the press shorthand. And it's wrong. He was ejected by officials of the Pennsylvania Horse Racing Commission on the stated rationale of the best interests of horse racing. And that phrase isn't my paraphrase. It's quoted in the federal opinion that later reviewed the whole thing. That same day, Gill told the Associated Press, quote, "What's going on here is just dirty business and dirty politics," end quote. And in the same story, "It's something I've dealt with in racing before." Read those two lines together and the shape of everything that follows is already visible. An official act he didn't like, answered the same day with an accusation of corruption. And, in his own words, a grievance he dates to before Penn National ever acted. Gill and his trainer sued the 6 commission officials in federal court. And this part deserves to be told precisely, because it has wins and losses for both sides. First, a fairness beat Gill's critics tend to skip. His case was not frivolous. In 2011, the court denied the official's motion to dismiss, finding a plausible property interest in a racing license. The claim had enough merit to go the distance. Then it lost on the full record. In October 2012, after a trial, the court ruled for the officials. 2 things inside that opinion carry this entire series. The first is a stipulation, agreed by both sides. Quote, "The ejections were not based on any violations of horse racing regulations by plaintiffs. No welfare violation. No doping violation. The ejection was a business call and no regulator ever found otherwise." The second is about process. Ejected owners had 48 hours to appeal. Gill's trainer appealed on time and had his ejection rescinded within a month. Gill did not appeal until May, and his late request was denied that July, with the words, "Gill's ejection is final." And when he was asked under oath why he hadn't appealed in time, Gill answered, "I knew what they were doing and how they were doing it." The appeals court affirmed the loss in 2013. One more fairness note inside this: when a Pennsylvania grand jury later brought charges tied to Gill's stable operation, they landed on his trainer, Dula Hussein. Gill was not charged and denied knowledge. Days after losing that trial, Gill put out a long public statement. And it matters less for what it alleges. None of it was ever adjudicated, and most of it can't responsibly be repeated, than for its date and its architecture. Because by May of 2012, the entire named enemies conspiracy narrative already existed. Roughly 10 named people, right down to a commission lawyer, he cast as the puppet master. That's 2 years before State of Corruption would exist as a website, and a year before he'd put a version of the same structure into a federal court filing. The statement's thesis line, word for word, "I would not be bought and I would not be intimidated." And notice what the statement does not contain. In Gill's own fullest account of the racing war, there is no claim that anyone offered him money. The specific dollar figure "they tried to buy my silence" claims only show up in tellings from about 2019 onward. I can't tell you no offer was ever made. I can tell you his own 2012 statement makes no such claim, and that no record I've reviewed documents one. Then something happened that Gill's defenders point to constantly, and they're partly right to. Starting in November 2013, federal prosecutors brought real criminal charges around Penn National in 3 waves. First, indictments against 3 trainers and a track clocker for wire fraud tied to race day doping and faked workout times. Then in 2014, a 9-person illegal sports betting and money laundering case. And in 2015, a man in the track's race entry office agreed to plead guilty to selling inside information. So here's the rule I'm going to hold to on this, and I'll say it whole every single time because either half by itself is a lie. Gill was right that there was crime at Penn National. The court still found his own ejection lawful. The people charged were not the people who ejected him. The overlap between those 2 groups is 0. And here's the part that really cuts against the vindication story. The Horse Racing Commission, the body Gill accused, was itself one of the investigating agencies on 2 of those cases. None of the charges involved Gill, and none of them touched the question of whether his ejection was retaliation. That question was tried separately, and he lost it. And precision on how the wave actually ended, because they were all convicted, would be false. The clocker pleaded and cooperated. One trainer's federal charges were dropped entirely for insufficient evidence. Another's federal case was dropped for a state plea, and one fought on. The last agreed to plead. 2 more corrections because they travel with this story online. 1. The claim that Gill predicted the indictments a year in advance is a racing columnist's characterization, not a quote from Gill. His first documented prediction of 200 arrests came in 2014, after the first indictments. 2. The money laundering through Penn National line. The only money laundering charges in the cluster attached to the sports betting ring and the charging documents never placed that operation at the track. The same shape and official act answered with an accusation of conspiracy didn't stay at the racetrack. It ported, almost intact, into the mortgage business. And here the record thickens, from press accounts into agency orders and federal dockets. In the summer of 2008, New Hampshire banking examiners examined the mortgage specialists, TMS, Gill's Plaistow company, then one of the region's highest volume brokerages. What examiners reported finding included documents pulled out of a shredding bin. Massachusetts regulators ran their own review, and at the end of July, New Hampshire referred its findings across the border. On July 24, 2008, New Hampshire issued an order to show cause against 5 people and entities: TMS, Gill, another officer, and 2 branch managers. The staff petition alleged, and I have to stress alleged, because no such findings was ever entered against Gill, a document alteration scheme, signatures photocopied, cut out, attached to new documents, and recopied. It threatened up to $200,000 per respondent and license revocation. That was the exposure. It was not the outcome. Keep those 2 things apart, because almost every retelling of this story collapses them, and that's where it goes wrong. On a single day, TMS resolved both states' cases by consent. And this is the exact spot where the careless version of this story falls apart. So I'm going to be precise. New Hampshire, a consent order of $425,000 in penalties, itemized right on the order. $50,000 from Gill, $50,000 from the other officer, $300,000 from the company, plus $25,000 for do not call violations. Massachusetts, a separate order from a separate regulator of $300,000, resolving a cease and desist whose findings had included the detail that became the case's signature. The same borrower, a state-employed nurse, listed at about $87,000 and then $99,000 a year across 3 loans, against payroll records showing about $17,700. So 2 figures that must never be blended together. The $300,000 piece of New Hampshire's $425,000 order, and Massachusetts' separate $300,000 order the same day. If you want a 2-state total, it's $725,000. And it's only valid as the sum of 2 distinct orders. And one sentence I'm never going to say, because it isn't true. He admitted fraud. He did not. Both orders preserved denials. The New Hampshire respondents expressly stated that no altered document was ever used to get a loan and that no consumer was harmed. Consent, in both states, was settlement without an omission. And it was not a revocation. No order in this entire record ever revoked TMS's license. There is exactly one personal admission in the whole 2008 file, and it belongs to one man. That October, a Salem branch manager named Colwett accepted a $75,000 penalty, most of it suspended, and agreed to leave the mortgage business for good. Whatever was admitted in that order was admitted by Colwett alone. I will never hang it on Gill. The file's last loose end closed in 2009 when the allegations against the other branch manager were dismissed without prejudice, which is neither a finding against her nor an exoneration, and I'm reporting it as exactly that. Massachusetts came back once more. A 2010 re-exam found TMS wasn't in full compliance, and a 2012 order added $48,000 for running business through unlicensed loan originators. That file was formally closed in 2014. In April 2013, facing a new New Hampshire enforcement case over failing to produce examination records, TMS did something remarkable. It sued the New Hampshire Banking Department itself in federal court for an injunction. And then the day after filing, it fired its own attorney. Gill appeared representing himself. One judge recused within 2 days. The chief judge denied TMS's motion to recuse him as meritless, and then recused himself anyway on his own initiative in the same order. TMS lost both of its emergency motions and the motion to dismiss, was given a chance to fix its complaint, never did, and the case died that August. That recusal order is one of the most important documents in this whole series, because of what it preserves. In laying out the complaint, the judge set down, for the first time on any court record, Gill's full conspiracy narrative, as Gill alleged it. That the banking department had conspired with Gill's own former lawyer, an attorney named Alexander Walker, and his colleagues to destroy the company and cover up the state's failure to catch a notorious Ponzi collapse. That Gill's own divorce attorneys had run up fees and destroyed evidence as part of the same plot. That company secrets had been leaked through a competitor. Every piece of that is Gill's allegation, recited by a judge never adjudicated. I'm telling you what he claimed, not what a court found. And here's the part to hold on to. That former lawyer at the center of it, Alexander Walker, went on to run one of the state's biggest law firms, and today is the president and CEO of a hospital. He is also the same man who, after Gill's campaign publicly branded him, won a $5 million defamation judgment against Gill. The lawyer Gill recast here as a conspirator is the lawyer who beat him in court. The same order preserves one more detail. The judge's own account that TMS's attorney of record kept professing that he didn't know the facts in the complaint and claimed he hadn't written it, even though the amended complaint carried his signature. 11 days after the federal case died, Gill showed up, this time with a lawyer, at a hearing in the state enforcement case. And there, according to the agency's own order, he demanded that the proceedings be videotaped so he could use the recording, quote, in a different forum or forums, to show what he called improper or illegal actions. When the hearing officer kept the proceeding closed, Gill refused to go forward and walked out. A default judgment followed on stipulated facts, $8,000 against the company, $5,000 against Gill. $13,000 total for failing to produce records and examination materials, not fraud. Now mark that date. 15 months before any website existed, Michael Gill stood in a hearing room and said on the record that he wanted footage for a different forum. State of corruption has a birth certificate. That's it. The final banking case ran on the same rails. At a hearing in late 2015, Gill again represented himself, the earliest point in the record where I can confirm he was doing that. The hearing was cut short, in the order's own words, because it was, quote, unable to be completed due to Mr. Gill's repeated interruptions and outbursts, and the case was decided on the written briefs. The final order fined the company $55,000 and Gill, individually, another $55,000. And I'll note the order states those as two separate totals, not one combined figure. For information security and anti-money laundering failures, the same problems the 2013 exam had already flagged. The New Hampshire Supreme Court disposed of the appeal in 2 words: summarily affirmed. After TMS declined to show up through a lawyer the way the court's rules require. And fairness demands the precision here. That ruling, like the big one still to come in the defamation case, was procedural. No appeals court ever reached the merits and agreed or disagreed with anything. The case is ended because Gill and the company stopped engaging with the process. The same move as 1995. The same move as the racing appeal he filed too late. And the same move as the walkout. The fuse was lit in a courtroom in the spring of 2014. The court file of that case is now in hand. His former law firm, the lawyers who had represented him in his divorce, had sued their ex-client to collect about $118,000 in unpaid fees. Gill answered with the earliest filed version of the story this whole series traces. Counterclaims accusing the firm of fraud and malpractice, and third-party claims pulling his own divorce attorneys into the case. Those third-party claims were dismissed on the statute of limitations. And across that case's 3 years, by the court's own count, Gill employed 11 lawyers. Quote, all of these attorneys were dismissed by the defendant at some point during the litigation, and some have been sued by him for legal malpractice. In the end, the defendant elected to represent himself. Now mark this. 3 weeks before any website existed, at the March 5th pretrial conference, the court wrote that it had, quote, a great deal of difficulty containing Gill's outbursts. His statements that the legal system was corrupt and that all parties involved in his divorce case were being investigated by the FBI, CIA, and other agencies. The trial began March 24th with a jury. On the second morning, Gill's conduct was, in the court's own words, cannot be adequately described. A verbatim record is required. The judge attached the transcript to his order. It ends with Gill turning to the jury. I hope you guys watch this video. Find out if the judge isn't included too. The firm asked for a direct verdict. The court entered judgment against Gill. With the fees it awarded for bad faith, about $234,000, and threw out his counterclaims with prejudice as a punishment. Gill's own website said the trial ended less than 1 hour into the second day. On that, his account and the record agree, and the judge wrote down what he had watched, in words I'm going to read exactly. Mr. Gill had a story to tell, and he was going to tell it in direct defiance of the court's rulings. He made $100 million in his business and could pay any amount in legal fees if he wanted to. Rather, he believed he had been wronged by the legal system, and he would do or say anything to expose that wrong. 12 days later, stateofcorruption.org was live. The site's first posts date to April 2014. Its banner tagline preserved in an archived capture: exposing corruption in the New Hampshire Banking Commission. Its audience counter, 5 weeks in, joined 92 other followers. The first video came at the end of May. And the detail that matters is the aim. This campaign wasn't born from the racetrack. It was born banking specific, weeks after a courtroom collapse. The second run of a pattern whose first run had played out in Pennsylvania 4 years earlier, almost beat for beat. Then the campaign left the internet. Electronic billboards and truck-mounted signs went up around southern New Hampshire, naming private citizens, a developer, an auto executive, a bank chairman, as corrupt and criminal. The specific accusations and the fact that they were false would eventually be established in the court record of the case those men brought. Hold that thought. We're about to get there. I don't drag a man's divorce into a corruption story, but the record shows Gill fused the two himself. First, his 2013 federal complaint had already cast his own divorce attorneys as conspirators. In March 2016, the collision turned physical. At a hearing in his own divorce case, a judge held Gill in contempt. Press accounts describe repeated interruptions after warnings and note he'd been recording the proceedings without authorization, and Gill spent roughly 10 days in jail. And that judge's name and face then went up on the billboards too. Everything I just said about the divorce comes from the federal court's recitation and from contemporaneous contempt coverage. None of it comes from the divorce file itself. In September 2016, Gill filed to run for governor of New Hampshire as an independent. The Secretary of State ruled him ineligible because he wasn't a registered voter. And in April 2017, a Nashua District Court fined him $31,900 in civil penalties because the electronic signs violated local sign ordinances, which is a completely separate matter from what the signs said. The three men on the billboard sued. Liability was resolved against Gill before trial, on summary judgment. A jury was brought in just to set the damages. And Gill did not hire a lawyer and did not attend his own trial. The third act of not showing up, after the walkout and the appeals he let lapse. And the largest. One more dated fact travels with that empty chair, and I'm offering it strictly as timing. 17 days before this trial, Gill was arrested on a contempt warrant out of the fee case, the one that started the campaign, for skipping hearings over that still unpaid $234,000 judgment. His bond was discharged 4 days before this trial began. Why he stayed away from his own trial? No record states. The jury returned $274.5 million. $92.5 million. $97 million. $85 million. One figure for each man. His former lawyer's separate case had already found him liable and would produce that $5 million judgment. And for the completeness of the record, both defamation judgments were appealed, and both appeals ended the same way. The New Hampshire Supreme Court affirmed the $274 million judgment in 2018 and affirmed the $5 million judgment in 2019. Neither ruling touched the merits. In each one, Gill's own self-written brief raised no proper question and made no real legal argument, and the court heard no oral argument. So both awards stood, not because an appeals court looked at the amounts and agreed, but on the same procedural default that had already ended his banking appeal. Once again, nobody properly argued them. Part 1 ends on the number, because the number is where the record pauses to take a breath. A man who was once the leading racehorse owner in North America, who built one of New England's highest volume mortgage companies, ended 2017 owing more than $250 million to 3 private citizens. An adjudicated defamer, out of racing, out of regulatory good standing, and increasingly out of the very courtrooms where his cases were being decided without him. What the record shows next is not a retreat. It's a reinvention, a bankruptcy, a question about who really owned what, and a version of Michael Gill whose claims stop being checkable at all. That's part 2.